They thought the stroke had taken my mind. They had no idea it had sharpened it. I was 67 years old when I woke up in a hospital bed that smelled like bleach and defeat. The doctors called it a mild ischemic stroke. Mild. As if there was anything mild about lying there. Your right hand, trembling. Your speech slow and deliberate as a man choosing words in a foreign language. My daughter was in the corner of the room, her back to me, her voice low. Her husband was with her. They thought I was asleep again. I had been drifting in and out for 2 days, and they had stopped being careful. The power of attorney paperwork, my son-in-law said. His name was Derek, and he had the kind of voice that always sounded like he was closing a deal. We need it signed before he gets better, before he starts asking questions. My daughter, Sarah, was quiet for a moment. I heard her exhale slowly, that same sigh she had given as a teenager when I asked her to be patient. He's going to fight it, she said. He can't fight it, Derek said. Look at him. His own doctor said he may never fully recover. We document the cognitive impairment now. While it's fresh, we get the POA. And then the rest follows naturally. I lay still. My hand was already trembling. I let it tremble harder. I breathed the way a man breathes when he's unconscious. My eyes stayed closed. The rest follows naturally. I had spent 40 years as a master woodworker. Not a weekend hobbyist. Not a man who refinished kitchen cabinets. I built custom furniture for collectors, for museums, for 2 governors, and 1 senator. I had worked with my hands since I was 15 years old, apprenticed to an old German craftsman in Cincinnati, who told me that a man who understands wood understands patience. Wood doesn't lie, he used to say. It tells you exactly what it is. It's people that hide things. The stroke had slowed my speech. It had shaken my right hand, but my mind was running as clean and precise as a freshly sharpened chisel. I kept my eyes closed and I listened. Derek was a financial advisor. He was 41 years old. He wore shirts that cost more than my first car. And he had married my daughter 8 years ago in a ceremony I paid for without complaint. I had always been polite to him. He had always been polite back, the way a man is polite to someone whose inheritance he is quietly calculating. I had never liked him, but Sarah loved him, or said she did. So I kept my mouth shut, and I kept my workshop locked, and I kept my business, my own business, the way my father taught me. My wife, Carol, had died 4 years ago. Breast cancer, swift and merciless. She had been the one who handled the house, the bills, the taxes. When she was gone, Sarah had stepped in with an offer I had accepted without reading the fine print. Let me help you, Dad. You shouldn't have to worry about all this at your age. Let Derek handle the investments. He knows what he's doing. I was grieving. I was grateful. I handed over my financial life the way a man hands over his car keys when he's had too much to drink. He trusts the person driving. He doesn't watch the road. That was my mistake. I lay in that hospital bed for 3 more days before they discharged me. I played the part of a man whose mind was soft at the edges. I stumbled over words I knew. I called Derek by the wrong name once, watched his expression shift not into concern, but into something that looked almost like relief. I asked Sarah the same question twice in 10 minutes. She answered patiently both times, and I saw her glance at Derek when she thought I wasn't looking. They were watching me the way you watch a fruit that's almost ripe. They set me up in my own house, which was kind of them. Sarah came every day. She cooked simple meals and left them labeled in the refrigerator. She organized my medications in a plastic pillbox with the days of the week printed on top. She was attentive. She was warm. She was performing for an audience that she believed couldn't evaluate the performance. I performed right back. I left my speech slow. I let my right hand shake when I picked up a coffee cup. I fell asleep in my armchair in the afternoons, or appeared to. I was not sleeping. I was thinking. I was reconstructing every financial decision I had made in the 4 years since Carol died. Every document Derek had handed me. Every signature I had placed on papers, I should have read more carefully. On the 5th day home, I asked Sarah if I could go to my workshop. Just to sit, I told her. Just to be around my tools. It calms me down. She hesitated. Derek said the workshop might be dangerous. Too many sharp things. Uneven floors. But Sarah overruled him. Just barely. She walked me out to the detached garage behind the house, unlocked it, and stood in the doorway watching me settle into my old rolling chair at the main bench. "It smells like you in here, Dad," she said, and her voice caught just a little. I believed that part was real. "I know, sweetheart," I said, my words coming out careful and slow the way they always did now. "You go on. I just want to sit with it a while." When she was gone, I sat still for 4 minutes. Then I reached under the bench and retrieved the small brass key I had taped there the day I first locked this space 22 years ago. I unlocked the bottom drawer of my rolling tool cabinet. Inside were 3 things. A prepaid cell phone I had purchased for cash at a gas station 6 months earlier during a trip to Columbus. I had never mentioned to Sarah or Derek. A handwritten ledger that had nothing to do with the bank accounts they managed for me, and a sealed envelope addressed to a man named Philip Cotter. I had purchased that phone in the fall, before the stroke, during those long suspicious nights when Carol's absence made the house too quiet, and Derek's too smooth. Explanations of my investment returns had started sounding wrong, in a way I couldn't quite name. I hadn't known then exactly what I was preparing for. I had just known, the way wood knows weather, that a storm was coming. I powered the phone on. The battery was still at 62%. Philip Cotter was 74 years old, and he was the most careful lawyer I had ever met. He had handled my business contracts for 30 years, back when I was building custom pieces for clients who paid in cash and signed nothing they hadn't read 4 times. He was retired now, mostly, but he answered on the second ring. "George," he said. "I was wondering when I'd hear from you." "The storm is here, Philip," I said. He didn't ask me to explain. He just said, "Tell me everything from the beginning." And I did. Over the next 3 days, moving slowly between my house and my workshop with my cane and my trembling hand and my careful, soft-edged speech, I did 3 things. The first thing I did was build a music box. It was a small walnut case, hand-jointed at the corners, with a simple spring mechanism inside that would play 8 bars of a folk tune Carol had loved. I had built music boxes before, dozens of them over the years. Sarah had seen me work on them. She would not think anything of it. But this one had a modification she would not see. Behind the melody comb, in a cavity I routed out with a bit no wider than a pencil, I placed a voice-activated digital recorder, no bigger than a book of matches. I wired it to a separate battery pack, and I sealed the back panel with 4 brass screws. From the outside, it was a beautiful, simple music box. From the inside, it was an ear. I carried it into the living room and set it on the side table next to the couch, where Sarah and Derek always sat when they came to talk to me. "It needs a few more days to cure," I told Sarah when she asked about it. "The finish. I don't want to rush it." She patted my arm. "That's fine, Dad. Take your time." The second thing I did was find out what they had done with my money. I could not access my own accounts directly. Derek had the passwords. Derek managed the accounts. That had been the arrangement. But Philip Cotter still had contacts at the Ohio Securities Division, and one of those contacts had access to public filings. What he found, relayed to me through 3 careful phone calls made from my workshop while Sarah believed I was napping, was not what I had expected. It was worse. 3 months before my stroke, Derek had filed paperwork through a Delaware shell company that moved a significant portion of my savings into an investment vehicle that he controlled. Not managed. Controlled. The distinction mattered legally, and Philip explained it to me in language I understood. The way you explain the difference between borrowed wood and stolen wood. Borrowed, you return it. Stolen, you build something else with it and claim it was always yours. The total Derek had redirected was $480,000. accumulated over 40 years of building things with my hands. I sat with that number in the quiet of my workshop for a long time. I ran my thumb along the edge of a piece of cherry wood I had been saving for a project I had not started yet. $480,000. It was not everything I had. They did not know about everything I had, but they thought it was everything, and that made their confidence complete and their caution careless. The third thing I did was wait. On the Thursday of my second week home, Derek came alone. Sarah was at work, he said. He just wanted to check on me, he said. He brought coffee from the good place downtown. He sat across from me in the living room, and he was warm, and he was careful, and he talked about my recovery, and about a specialist he had found in Cleveland, who was very good with stroke patients. Very good. Someone I should really consider seeing. I thanked him. I let my hand tremble around the coffee cup. Then he said, gently, leaning forward with his elbows on his knees, the way a man does when he's about to deliver something disguised as concern, that he and Sarah had been talking. They were worried about me living alone. They thought it might be time to discuss some options. Not right now, he said, smiling. Not today, but soon. Options, I repeated, letting the words sit in my mouth like I wasn't sure of it. He nodded. Comfortable places. Places with staff, with medical support, places where I wouldn't have to worry about anything. I looked at him. I made my eyes go soft and grateful. That sounds nice, I said. He left 40 minutes later. When his car pulled out of the driveway, I waited until I could not hear the engine anymore. Then I walked to the side table and I retrieved the music box and I took it to my workshop and I pulled the back panel and I recovered the recorder. I sat in my rolling chair and I played it back through a small speaker. I heard myself and Derek speaking. I heard his careful, warm voice asking about the Cleveland specialist. But before I had come downstairs, before I entered the room, there was something else on the recording. His voice, alone, low, on the phone. She's worse than we thought, he was saying. She's not going to fight it. She signed the thing in the hospital. She has no idea what she signed. Just like we expected. The Cleveland thing is just to establish the paper trail for the guardianship petition. Once we have that hearing scheduled, the rest is clean. Yes, just get the papers to my office by Friday. I sat with that for a moment. She has no idea what she signed. I thought back to the second day in the hospital. A nurse had come in with paperwork. Insurance forms, she said. Derek had already filled in most of it. Just here and here, he said, pointing. My hand was shaking. My vision was still blurry at the edges. I had signed. I was not angry. Something had moved past anger. Past it entirely. Into a cold and very clear place that I recognized from 40 years of working with difficult material. When you find a hidden fault in a piece of wood, you do not get emotional about it. You assess it. You decide what it changes. You adapt your design accordingly. I called Philip Cotter that evening. Here is what we know, I said. I told him about the recording. I told him about what I had signed in the hospital. I told him about the $480,000 and the Delaware Shell Company. I told him that Derek had been on the phone before I came downstairs, and that whoever he was talking to was expecting legal papers by Friday. Philip was quiet for a moment. George, he said, do you trust me? I have trusted you for 30 years, I said. Then I need you to do exactly what I tell you, and not one thing more. Can you keep playing this the way you've been playing it? I can play it until opening night, I said. Philip Cotter had a way of doing things that left no loose ends, no unsecured joints, no gaps in the grain. He had spent his career in business law, but his brother had spent 30 years in family court, and his brother still had colleagues. Within 48 hours, Philip had established two things. First, that the signature I had placed on that hospital document was legally challengeable on grounds of cognitive incapacity at the time of signing, meaning Derek had exploited a man who had just suffered a neurological event. That was not just unethical. That had a specific criminal name in Ohio. Second, that the guardianship petition Derek was apparently preparing would, when filed, land in the courtroom of the Honorable Raymond Stafford, a family court judge who had been one of Philip's law school classmates for 3 years and who had a particular intolerance, professionally documented, for financial elder abuse. I did not contact Judge Stafford. That would have been wrong, and Philip would not have allowed it. But Philip sent a letter, not about the case, a letter with a single photograph enclosed of 3 young men standing outside a bar in Cincinnati in 1976, laughing at something off camera. Philip was on the left, Raymond Stafford was on the right, and the man in the middle, the one laughing the hardest, was my late brother Daniel, who had introduced them both. The letter said only that Daniel's brother was in trouble, and that Philip believed the court would find the upcoming proceedings very interesting. I did not know about the letter until much later. Philip is careful that way. He does not share the mechanism until after it has done its work. I kept playing the part. Sarah visited. Derek visited. I dropped words, misplaced thoughts, called Derek by the wrong name twice more, and watched him absorb each mistake with a satisfaction he was no longer bothering to completely hide. He had stopped seeing me as a person. I was a process now, a sequence of legal steps that would conclude in an outcome he had already spent. The summons arrived on a Tuesday, hand-delivered by a man in a gray sedan who did not meet my eyes when he pushed the envelope into my shaking hands. I was being invited, the papers said, to appear before the court to determine whether I required a legal guardian for my health, financial affairs, and general welfare. The petitioners were my daughter, Sarah, and her husband, Derek, my daughter. I stood in the doorway of my house for a moment after the man left. The October air was cold. The trees in the yard had gone the color of old bourbon, that deep amber I had always loved in cherry wood. I had planted the big oak in the corner the year Sarah was born. I had pushed her on a swing tied to its lowest branch for 15 summers. I went inside. I sat at the kitchen table. I allowed myself, for a few minutes, to simply feel what I felt. Then I called Philip Cotter and I told him the hearing date, and he said, but I had a different idea about what to wear. The morning of the hearing, I put on the clothes I wore to the workshop. Not the ones I wore for deliveries. Not the clean ones I kept for client meetings. The ones I wore when I was deep in a project, worn at the knees, soft at the elbows, smelling faintly of linseed oil and wood shavings. I did not shave. I combed my hair, but not carefully. I took my cane, and I walked slowly to the taxi I had called from the prepaid phone, and I rode to the courthouse without telling Sarah or Derek I was coming. I wanted them to see me walk in. Courtroom 4 was on the 2nd floor. I pushed through the heavy door, and I entered slowly, my cane tapping on the floor, and I looked around the room like a man who wasn't entirely sure where he was. They were at the petitioner's table, Sarah and Derek and their attorney, a man in a very expensive suit who had the look of someone accustomed to winning cases before they started. Sarah saw me first. Something crossed her face too fast for me to name. Derek saw me a second later, and he leaned toward their attorney and said something quietly, and their attorney looked at me and nodded with the small, tolerant smile of a man looking at something that will not inconvenience him. In the gallery behind them sat a woman I did not recognize. She was perhaps 50. Dark hair pulled back. A plain jacket. She was watching the room, the way a person watches it when they already know what's going to happen. I made my way to the respondent's table. It was empty. I sat down alone. Derek glanced at me, satisfied that I had no attorney, no representative, nothing but my trembling hands and my old clothes and my cane. Sarah kept her eyes forward. She had not looked at me since I sat down. I watched her jaw set. That same expression she'd had since she was a child, when she was doing something she had decided was necessary. I had always respected her ability to decide. I had not anticipated how it would feel when that decision was made against me. Their attorney stood when the judge entered. We all rose. Judge Raymond Stafford was in his late 60s, broad-shouldered, with the unhurried movements of a man who understood that the pace of a room was his to set. He took the bench and surveyed the courtroom with the expressionless attention of someone reading a document he has read many times and finds interesting anyway. He saw me. His eyes passed over me for exactly 1 second longer than they passed over everything else. "Counselor," he said, "you may begin." Their attorney was very good. He structured his argument like a house being built from the foundation up. He established my medical history, the stroke, the recovery timeline, the documented speech, and motor impairments. He presented an affidavit from a neurologist, a lengthy clinical document that described the potential for ongoing cognitive decline following an ischemic event of my type and severity. He presented financial records showing the complexity of my estate and the difficulty any impaired individual would face in managing it alone. He spoke of Sarah's devotion, her daily visits, her concern. He described Derek's professional expertise, his credentials, his years of careful stewardship of my financial affairs. He built the case the way a lesser craftsman builds a cabinet. Solid enough from a distance. No attention paid to the joints. Then Sarah stood. She had prepared a statement. She held the paper in both hands, and she read it without looking at me. And her voice was steady. She described her fear when I had the stroke. She described the confusion I had shown in the hospital. She described the moment, and this landed in the courtroom like a stone dropped in still water, when I had signed the medical power of attorney in the hospital, in her presence, and Derek's, acknowledging with my own hand that I recognized my limitations and wished for them to act on my behalf. The courtroom was quiet. Stafford looked at the document their attorney had submitted into evidence. He looked at the signature, which was mine, slow and uncertain, the signature of a man whose hand was shaking. He looked at me. "Would the respondent like to speak?" he said. I stood up. I let my right hand grip the edge of the table, and I did not let it shake, not even slightly, and I watched Derek's expression flicker. "Your Honor," I said, my voice clear and unhurried, "there is someone in the gallery who has not yet been introduced to the court." Stafford looked at the gallery. The woman in the plain jacket. She stood at my words. "My name is Eleanor Marsh," she said. "I'm an investigator with the Ohio Department of Commerce, Securities Enforcement Division. I'm here at the request of Mr. George Allard's legal counsel, Philip Cotter, who is also present in this proceeding." Philip walked through the door at that moment. Because Philip had been waiting in the hallway. Because Philip does not enter a room before his cue. He was carrying a briefcase and he set it on the table beside me, and he straightened his tie and he said, "Good morning, Your Honor." Philip Cotter, appearing as counsel for the respondent. I heard Derek's attorney say something low and urgent. I heard Derek say something back. I did not look at them. Stafford said, "Mr. Cotter, I understand you have materials to present." Philip opened the briefcase. "Your Honor," he said, "we have 3 items for the court. The first is a certified forensic analysis of the document my client signed in the hospital, conducted by an independent document examiner retained by my office. The analysis establishes that the signature was obtained within 72 hours of an acute neurological event, during a period in which my client was on sedating medications and in demonstrable cognitive distress. Ohio Revised Code 1337.26 is specific regarding the validity of powers of attorney signed under conditions that impair understanding. This document," he said, placing it on the judge's bench, "establishes that the signature is legally void." Derek's attorney was on his feet. "Your Honor, this is the first we've seen any of this." Stafford held up one hand. "You'll have the opportunity to respond, Counselor. Let Mr. Cotter finish." "The second item," Philip said, "is a recording." He looked at me. "My client built this device himself." He placed the music box on the edge of the judge's bench. It was the small walnut case, gleaming where I had oiled the corners. A beautiful, simple thing. He opened the back panel and removed the recorder, and he handed it to the bailiff who connected it to the courtroom's audio system. Derek was very still. He was staring at the music box, the way a man stares at something he does not understand and is beginning to fear. The recording played. The courtroom heard Derek's voice, unhurried and confident, in the moments before I had come downstairs. She signed the thing in the hospital. She has no idea what she signed. The Cleveland thing is just to establish the paper trail for the guardianship petition. Once we have that hearing scheduled, the rest is clean. Sarah's head turned toward Derek. Not fast. Slowly. The way something turns when the weight it was carrying shifts suddenly to one side. He did not look at her. The recording continued with our conversation. My careful soft words and his careful warm ones. The Cleveland specialist. The comfortable options. The places with staff. You could hear in his voice the particular gentleness of a man who is not being gentle at all. When it ended, the room was very quiet. Stafford looked at Derek. He looked at Sarah. He looked at Derek's attorney, who had the expression of a man watching a structure he believed was sound, to begin to separate at every joint simultaneously. "The third item," Philip said. And now his voice had a quality I had only heard a few times in 30 years. A stillness that meant he was doing something he had been waiting to do for some time. "The third item is a complete financial audit conducted by Miss Marsh's division, documenting the unauthorized transfer of $480,000 from my client's personal investment accounts into a Delaware limited liability company controlled solely by the respondent's son-in-law, Derek." The room reacted. I did not. I was watching Sarah. She was looking at Derek now with an expression I could not read. It was not the expression of a woman who knew and was pretending not to know. It was the expression of a woman who had just found a fault in a piece of material she had believed was solid. I had been wrong, I realized. Or partially wrong. She had agreed to the guardianship. She had believed Derek's version of my condition. But the money, the $480,000, moved through a company she had likely never seen a document for. That had been Derek's project. That had been Derek's design. She had been, in her own way, a piece of wood he had worked with, without telling her what he was building. "Your Honor," Derek's attorney said, and his voice had changed entirely. His voice had the quality of a man trying to find solid ground and discovering that the floor is not where he thought it was. "My client strenuously denies any improper transfer. Whatever documentation the Securities Division believes it has, there is a full and proper accounting." "There is indeed a full accounting," Philip said pleasantly. "We have it here." He placed the audit on the bench, beside the rest. Stafford looked at it for a moment. Then he looked at Derek's attorney. Then he looked at Derek. "Mr. Derek," he said, "you are the petitioner in this case. And you have also just been the subject of a credible criminal referral by a state investigative division in my courtroom. I want you to understand that the proceedings before me now are civil, but that nothing prevents Miss Marsh from acting on what this court has received into evidence." Derek's attorney put a hand on his arm. Derek did not speak. Stafford turned to look at me directly. He looked at my old clothes, my unshaven face, the cane leaning against the table. "Mr. Allard," he said, "I understand you built the device that produced that recording yourself. After a stroke." "Yes, Your Honor," I said. "What is your profession?" "Custom furniture," I said. 40 years. He nodded once. Very slowly. The nod of a man, confirming something he already knew. He looked at Sarah. She was looking at the table in front of her. Her hands were flat on the surface. Very still. Stafford said, "I am dismissing the guardianship petition in its entirety. I am also entering a finding that the power of attorney document signed in the hospital is legally invalid under Ohio Revised Code as presented." He paused. "Miss Marsh, you'll be coordinating with the county prosecutor's office?" "Already in progress, Your Honor," she said. Stafford looked at Derek's attorney one more time, with the expression of a man who has found the work to be exactly as careless as he had suspected. Then he lifted the gavel, and he set it down, and the sound of it filled the room. Derek stood immediately. His attorney grabbed his arm and said something fast and quiet. Derek pulled away. He turned, and he looked at me, and for a moment I saw the mask drop entirely. What was underneath was not rage. It was something smaller and uglier. It was the expression of a man, who has been caught, not in a grand dramatic betrayal, but in a simple, mean arithmetic. He had calculated that I was worth more passive than active, worth more confused than clear, and he had been wrong, and he knew it. And that knowledge was already changing the shape of his face. Then he walked out. His attorney followed. The sound of the door closing was the flattest, least dramatic sound I had ever heard. And it was exactly right. Sarah stayed in her seat. I did not approach her immediately. Philip gathered our materials. Miss Marsh shook Philip's hand and then shook mine, her grip businesslike and warm. The room emptied gradually, the way rooms do after something has been resolved. People moving away from the center, the way water moves away from a dropped stone. Sarah was still at the petitioner's table when I finally crossed the room and stood beside her. She did not look up right away. When she did, her eyes were dry. Her face had the particular stillness of a person who has just recalculated something fundamental. "I didn't know about the money," she said. "I know," I said, "but I believed him." "About you." About the she stopped. I believed the cognitive decline. He showed me things. Reports. Things that looked real. I sat down in the chair beside her, not across the table. Beside her. I set my cane against the back of the chair, and I looked at my hands for a moment. The left one steady, the right one with its fine, persistent tremor that would probably never fully go away. "I'm not the man I was," I said. The stroke changed some things. He wasn't wrong about that part. "But your father is not a ward, Sarah. Your father is a craftsman, and a craftsman understands the difference between a thing that's damaged and a thing that's finished." She looked at me then, really looked, and I watched something in her face move through several expressions too fast to name before it settled into something that was not yet okay but was at least honest. We sat there for a while in the empty courtroom. I did not tell her it would be fine immediately. I did not offer her easy comfort that neither of us had earned yet. We sat in the honest quiet of two people who needed to find out what was still standing. Outside, in the parking lot, Philip was waiting for me. He handed me a single sheet of paper. The current valuation of an investment account in my name that Derek had not known to look for, an account I had opened 22 years ago, after a long conversation with my accountant at the time, a careful, quiet man who told me that a craftsman should always have a piece of inventory no one else can appraise. It was modest, but it was mine, entirely and cleanly mine. And it had been growing quietly in the background of my life like a good piece of wood waiting for the right project. "George," Philip said, "you should know that Raymond Stafford called me last night, after he received my letter." "What did he say?" "He said, 'Tell your friend to wear something decent to court.'" He paused. "I told him, you had your own ideas about that." I looked at the courthouse behind us. The stone of it was old and worn in the way that things get worn when they have been doing their job for a long time without complaint. "I need to get back to my workshop," I said. Philip smiled. He was already pulling his car keys from his pocket. The oak in my backyard had dropped half its leaves by the time I got home. I stood in the yard for a moment looking at it, at the high branch where the swing rope had left a permanent pale groove in the bark over all those years of carrying weight. Wood remembers pressure. It changes shape around the things it has held. I unlocked the workshop. The smell of it came out to meet me. Linseed and sawdust, and the particular resin of old cherry wood. The smell of 40 years, and everything I had built in them. I hung my cane on the hook by the door. I sat at my bench. On the surface was the piece of cherry wood I had been saving. I had not yet decided what it wanted to be. I ran my thumb along the grain the way I had done 1,000 times, feeling for the direction of it, the tension in the fiber, the place where the figure turned and became something you could not have predicted from the outside. There is a kind of patience that is not passive. It looks like stillness from the outside, but inside it is running as fast and precise as a well-made mechanism, calculating, adapting, waiting for exactly the right moment to apply exactly the right pressure. That is the patience my German teacher tried to explain to me when I was 15 and too impatient to fully understand. I understood it now. I picked up my marking gauge, and I began. Before I close, I want to tell you one more thing. Not about the court, not about Derek, not about the money, about the music box. It is sitting on the table in my living room. The back panel is open, and the recorder is gone, but the melody mechanism still works. The spring still holds. I wound it last night, and it played 8 bars of the folk tune Carol had loved. A simple, repetitive thing with a sweetness that catches you differently depending on what you are carrying when you hear it. I do not keep it there because it was the instrument of anything. I keep it there because I built it well. Because it is a beautiful object that does exactly what it was made to do. Because in 40 years of making things with my hands, I have learned that the most honest thing a craftsman can say is not what his work is worth, but what it is. It is exactly what it appears to be. Nothing more. Nothing less. That is all any of us can ask. If this story reached you, hit like and leave a comment below. Tell me where you're watching from. And subscribe to Revenge Accounts, because justice doesn't always look loud. Sometimes it looks like an old man in a workshop, and a small walnut box, and a very long patience.